My name is Professor Pierre de Vos. I'm the Claude Leon Foundation Chair in Constitutional Governance in the Department of Public Law at the University of Cape Town in South Africa. I'm an expert on South African constitutional law, and in 2005 I gave testimony before the South African Parliament when it was considering the adoption of legislation to extend the legal rights to marry to same-sex couples. This legislation was drafted to give effect to a judgment by the South African Constitutional Court in the case of Minister of Home Affairs and another versus Fourie and another. Parliament subsequently adopted the Civil Union Act, which granted full marriage rights to same-sex couples. During the parliamentary hearings, I explained why it was important for the protection of the inherent dignity of every gay man, lesbian, transgendered and bisexual person that the legislature do two things. First, to extend full legal rights associated with marriage to all same-sex couples. But secondly, and very importantly, to ensure this is done in a manner that bestows on same-sex relationships the same symbolic status associated with traditional marriage. I did this by invoking my own mother, saying only half-jokingly that every mother wants and deserves to have a picture of a son or daughter on his or her wedding day on the mantelpiece in the house. So underlying this joke was the following analysis, which I am now going to attempt to provide to the court. In the Minister of Home Affairs versus Fourie, the South African Constitutional Court had to decide whether excluding same-sex couples from marriage was indeed discriminatory in terms of the Constitution. It considered this against the backdrop of South Africa's history. During the apartheid era, the state drastically limited the rights of individuals to engage in and have their intimate relationships recognized by the state. For example, there was the Immorality Act, which criminalized sexual intercourse between white and black people, and the Prohibition of Mixed Marriages Act, which prohibited marriages between white and black people in South Africa. There has therefore been a long history in South Africa of interference with the all-important life-enhancing choices people make about the intimate actions and the relationships that they care for. And so the court really implicitly argued that if you are going to prohibit same-sex couples from entering into same-sex marriages, it is akin to the apartheid era where black and white people were prohibited from entering into a marriage. The court said that the aim of the constitutional prohibition on sexual orientation discrimination was in part to prevent the state from interfering in these kinds of choices. Affirming that the decision to marry was worthy of constitutional protection, the Constitutional Court found that marriage was an important and unique institution and constituted much more than a piece of paper. On the one hand, it pointed out that in South African law, marriage had previously been the only source of socio-economic benefits, such as the right to inheritance, medical insurance coverage, adoption, access to wrongful death claims, and so on. But on the other hand, the court also noted that marriage was about more than gaining legal access to such benefits, as it bestows a myriad of intangible benefits on those who choose to enter into it. As such, marriage entitles a couple to celebrate their commitment to each other at a public event, and this is very celebrated in our society. Couples who marry are showered with presents and throughout their lives are able to commemorate this event at anniversaries, while pictures of the day can be displayed in their house and in the houses of their families. Given the centrality attributed to marriage and its consequences for most South Africans, the court argued that to deny same-sex couples a choice in this regard, and I'm quote, would be to negate their right to self-definition in a most profound way, end of quote. where the law failed to recognize the relationships of same-sex couples in the same way that it recognizes heterosexual couples' relationship, quote, the message is that gays and lesbians lack the inherent humanity to have their families and family life in such same-sex relationships respected and protected. It serves, in addition, to perpetuate and really reinforce existing prejudice and stereotypes in society. Thus, the court found that the denial constitutes a crass, blunt, cruel and serious invasion of the dignity of gay men and lesbians. In a pivotal passage, the Constitutional Court of South Africa concluded this aspect of the judgment in the following terms, and I'm quoting from paragraph 70 of the judgment. The exclusion of same-sex couples from the benefits and the responsibilities of marriage, accordingly, is not a small and tangential inconvenience resulting from a few surviving relics of societal prejudice destined to evaporate like morning dew. It represents a harsh, if oblique, statement by the law that same-sex couples are outsiders and that their need for affirmation and protection of their intimate relationships as human beings is somehow less than that of heterosexual couples. It reinforces the wounding notion that they are to be treated as biological oddities, as failed or lapsed human beings who do not fit into normal society. Because the exclusion, and like in the quote there, because of the exclusion of same-sex couples from marriage has both practical and symbolic impact, the court held that the problem cannot be rectified through the recognition of same-sex unions outside of the law of marriage. Accordingly, the court said, in responding to the unconstitutionality of existing marriage regime, both the practical, legal consequences and the symbolic aspects of marriage and marriage rights have to be responded to and have to be extended to same-sex couples. Thus, it would not be sufficient merely to deal with all the practical consequences of excluding same-sex couples from the institution of marriage. It is also important to allow same-sex couples to acquire the symbolic benefits of getting married. So the law needs to be changed in such a way that it allows same-sex couples not only to enter into some kind of union or pact, but actually to get married in exactly the same way. Otherwise, same-sex couples would not benefit from the symbolic value of entering into a relationship. The court said, if you don't extend exactly the same right to marry, and not only some kind of other legal arrangement to same-sex couples, it will be akin to what happened in apartheid South Africa during the racial discrimination era, where the government of the day argued that people could be separate but equal. The court said, where there's one group that is marginalized, that is discriminated against in society already, a regime where the two groups are not allowed to enjoy the same rights, but in the same space, but in separate spaces, where there's a separate but equal regime, that will still discriminate against same-sex couples. South Africa's anti-discrimination jurisprudence in this regard is clear, and the court focused on the fact that in discrimination law, one focuses on the impact of the discrimination. And the court said that if you exclude same-sex couples from the practical advantages of getting married, but also the symbolic advantage of actually calling yourself married in a marriage that is recognized formally by the state, it will have a very severe impact on the lives of gay men and lesbians. And the court said as follows what that impact will be at paragraph 78. Bearing in mind the symbolic and practical impact that exclusion from marriage has on same-sex couples, there can only be one answer to the question as to whether or not such couples are denied equal protection and subjected to unfair discrimination. Clearly they are, and in no small degree. The effect has been wounding, and the scars are evident in our society to this very day. By both drawing on and reinforcing discriminatory societal practices, the law in the past failed to secure for same-sex couples the dignity, the status, the benefits, and the responsibilities, because there are also responsibilities, that it accords to heterosexual couples. Although considerable progress has been made in specific cases through constitutional interpretation in South Africa to extend the rights to same-sex couples, as I believe is also the case in Colombia, that in itself is not sufficient protection. The court thus concluded that the prohibition on same-sex couples from getting married constitute unfair discrimination and ordered the South African legislature to fix the problem. The court could come to this conclusion partly because it considered and rejected all the arguments put forward as to why the exclusion of same-sex couples from marriage may serve an important purpose. Unfortunately, I have not time to deal with those arguments, but those arguments can be looked at in the Fourie judgment from paragraph 86 to about paragraph 100 of the judgment.